is from January 21, you have abandoned your service for the last 5 years. All of a sudden, you appear and say, accept my resignation, 5 years is complete. So you are rendering that provision redundant. Then everyone will start doing this. Wonderful. Then it means nothing.
Only subject to kindly, what is my understanding of the earlier judgment of this,
Let us see the earlier judgment. What it says. Come.
If your lordship takes up,
Start from page 66.
Page 65, your lordship may state, in view of page 65.
Yes.
I am reading, in view of the above facts, we proceed to decide the matter, bearing in mind the aforesaid amendments having its applicability and whether a petitioner has been able to make out a case that the order of the authority relying the said amendment is per se illegal and cannot be stand independently.
By the the provision which they are relying upon, it is couched in a language which leaves no ambiguity. It says at least 5 years. It says continuous, taking into consideration every service. So there is no scope for any leniency that even this study will be included and this will not be included. You read page 66.
Yes,
what it says.
Just thereafter, the amendment was with virtue of notification number such and such. The provision inserted in sub-rule 1 of Rule 34A of West Bengal Service Rules in the following. The provided that the provision under sub-rule shall not applicable in respect of officers in the cadres of West Bengal Health Service, West Bengal Medical Education Service, West Bengal Public Health Administrative Service, West Bengal Dental Service, and West Bengal Dental Education Service prior to completion of a period of at least 5 continuous years. At least 5 years. Yes. Yes, with the effect from date of joining to any such cadres or different cadres taken together as the case may be.
So, 5 years of continuous service at least.
Yes, but in this
they have used the word continuous. They have not just said service.
I bow down to your lordship. But
so when you are not getting a salary, is that continuous service? No, can it be?
No, I'm not saying, then but only thing your lordship will this very order.
Since 21, if you have not got a salary, then it is not a continuous service.
If your lordship kindly takes up 66 last paragraph once.
Yes.
Such being the situation, admittedly the letter of resignation was tendered before completing 5 years.
That's not the issue here. The issue is continuous 5-year service. There is no dispute in that person's case that he was serving continuously. That's not a dispute. So therefore, in the meantime, the time has lapsed. In your case, if we exclude from January 21 till today, then 6 years is gone. How much service you have been left with? It is pegged at 2 years, 1 day. It has not increased for 1 day thereafter. Whatever is recorded in the order,
yes,
it has not increased by even 1 day thereafter. 2 years, 1 day. Because you never joined. There is no service after that.
In this case, also, Shomo Krishna Vishwas also, he also never joined after tendering.
Let's show from the order that he never joined. Please show.
I'm trying to convince you.
We have looked at it. Therefore, we are saying, where is this issue in his order that he did not join?
Such being the position, admittedly, the letter of resignation was tendered before completing 5 years of continuous service from the date of joining, and therefore we do not find any infirmity or illegality in the decision of the authority based upon the said notification dated such as his also case was rejected on the same ground. However, the matter is sub judice as the order of the tribunal is assailed before us under 226 of the Constitution. Admittedly, as on the day respondent has completed 5 years of service counted from the date of joining 3rd November 2015. The tribunal ought to have taken into account the aforesaid facts when the challenge was made. The decision of the authority by taking completion of 5 years of service at the time of disposal of the tribunal application. Undoubtedly, the 5 years expired even in the day when the tribunal application was filed and came up for final consideration. There is no pleading required in this regard. The moment the pleading is explicit, the date of joining and date of filing the tribunal application necessary to taking into subsequent events to minimize litigation to avoid multiplicity of proceeding. Even if the letter of resignation tendered when the embargo is in vague, yet by the passage of time, embargo has been lifted and therefore there is no necessity to relegating the parties to the domain of authorities afresh, as it will be a replication of the same grounds, same facts, and the grounds tendered in resignation would survive. It will never give a new address to the original thing, and the approach has to be different. Such as an embargo is no longer operating against the respondent. It will be replication of the same facts. Therefore, we feel that justice requires the said letter of resignation to be considered in the light of relevant provisions prevalent as on date and should not be dismissed on technicality, more particularly applying embargo created under provisions of virtue of notification 26 August 16. Well, my contention is this, my lord, in that case also, my lord, the incumbent concerned, Subject Lordship kindly,
Sir, you have to read from the judgment these facts. You cannot make a submission without there is any without any foundational fact in the judgment. How are you making the submission? Where is recorded by the judge or by the bench that even though he is absent now 5 years is complete, therefore we are allowing him? This is not a fact there.
my lord, may I, my lord, Subject Lordship can't leave, my lord. May I come back with the resignation tendered by Shomokrishna Vishwas, as well as I was also there. My lord,
We will not reopen that matter. We will go by the judgment as it is. We are not here to look into the background. We are only to follow the judgment. That's not the way of taking up a precedent. One does not look into the file to see the context. One has to go by the judgment. That's all.
Absolutely. My lord, in that Shomokrishna Vishwas case, my lord, again the same order was passed that compelled the petitioner to move a contempt.
Please show any judgment. This one you have seen, we have not seen. And we are prima facie satisfied. There's no infirmity in the order passed by the authority. If they allow this, then their provision becomes redundant. It becomes meaningless in the book. So without challenging it, you will get over it. Wonderful. There's no way it can be read like that. And this is the way you serve the public after taking up an appointment. Only interested in your own betterment. And after that, you say, I'm practicing. Just look at the way you have approached the authority. You say, after that, I'm already practicing. Let me resign. So this rule means nothing to me. Wonderful approach.
No, my lord, if your lordship, my lord, Subject Lordship kindly, my lord, but if your lordship takes up, my lord, the contempt which was taken out by the petitioner against that order.
Which order?
My lord, against the Shomokrishna Vishwas order, my lord, on contempt.
We are not going to look into that. We will not. We will not. This is the judgment by which we are bound as a judgment of the coordinate bench. Why should we look into what happened in the contempt, under what compulsion? See, in a contempt, whether the judgment is right or wrong, they are bound to comply. So therefore, the contempt order does not mean anything as a binding precedent for the issue decided by the order.
Absolutely. Absolutely.
That does not mean that the order is correct. That does not mean that the order is incorrect. Whatever it is has to be complied.
But there is another order, although it's not been annexed.
So even if they were raising such issues, the court can say that will not allow you now because you have suffered a judgment, you comply it.
That's true. In the contempt, they cannot go any further.
They cannot. So therefore, we are bound by this. Nothing else.
There is another judgment of this that very coordinate bench, that of Devashish Mukherjee. You will place it tomorrow, I will place that judgment even. It's on same score.
You don't find any infirmity in the order passed by the authority. You cannot resign like this. We will not permit such persons. Come tomorrow.
No, my lord, another part, my lord. Only thing, my lord. Original application, my lord, that is of Mukutmuni Odhikari, that says, my lord, if I'm a temporary, but I'm temporary, that is not in dispute. If I'm temporary, my lord, the rules 34A is not applicable. This was, my lord, decided by the tribunal, upheld by this court, matter went up to the Supreme Court. Well, the Supreme Court has not passed any stay. Now, the fact is, this Mukutmuni Odhikari, well, that judgment is also here. If your lordship takes up the judgment of Mukutmuni Odhikari, it starts from page, my lord, all three judgments are there. My lord, it starts from, my lord, page 84. 84 is the tribunal's order, my lord, followed by the this honorable court's order, and by the Supreme Court. If your lordship takes up, my lord, the tribunal's order starts from 84. This honorable court's order starts from 87.
No, he was a temporary appointee.
But in my case also, I'm also not confirmed on a temporary appointment.
Please, sir, read the second paragraph at page 89.
Yes, ma'am.
We understood what you are trying to say, therefore we observe. In view of the aforesaid, we are in agreement with observation of the learned tribunal that since the applicant was appointed temporarily, he was not on probation.
Yes, madam.
So therefore, it was a temporary appointment,
Madam, your lordship,
not a confirm appointment, but going through the probation phase.
madam, my case, my lord, the appointment is provisional. It's provisional.
Every appointment is provisional. You show one appointment letter which says it is not provisional.
It has to be provisional. My lord.
These are settled principles of service law. What are you arguing?
My lord, I will come back with the judgment of Devashish Mukherjee, my lord. Your lordship, fix it tomorrow, my lord. If I can succeed, I will.
That's why we said you come if you can find anything that supports you.
Can it be day after tomorrow, my lord? Tomorrow, day after tomorrow.
All right.
Day after tomorrow. My lord.
As played by London. If he can bring some precedent, then we are bound. We don't proceed.
Well, I will try my luck, my lord. Let's hope for the best.
Why all the doctors are abandoning the service in the state?
Well,
Wherever there is
Item number 328.
I appear for the respondent bank. In terms of my lord's last order of 17th March, we were required to file the paper book incorporating the bank's rule regarding my lord the appointment of a peon and a sweeper, as well as my lord one advertisement which was in Bengali vernacular. Lordships wanted it to be in English translated copies.
Can we have a brief background? What the issue is?
The issue is that I appear for the appellants over here. Appointment procedure was challenged by an unsuccessful candidate who was not qualified at that juncture. This is a post appointment to the post of peon and sweeper. So we have qualified. We accordingly started our service. Thereafter, it was challenged by him. The honorable single judge was held that no, since there was a capping with respect to the higher qualification, that is the reasons we were disqualified from the service. Challenging that, we approached the honorable division bench. Division bench held in our favor, which was tested by the bank again in a review application. Further, which was rejected. Further, it was challenged before the honorable Supreme Court. Supreme Court has remanded back the matter before this honorable court. Because for the first time before the Supreme Court.
Because it was recorded by the honorable judge that no such provision has been brought to. Now we remember.
Yes.
Yes. So where is that provision? Let's see.
My
That's
lord,
all we have to.
The paper book, my lord, if lordship takes the my lord supplementary paper book,
Hmm.
which is my lord the thinner one.
Mm-hmm.
My lord, first appeal, which is my lord appeal number FMA 2071, pertains to a post of peon. So lordship will kindly come to page 25, my lord. which is, my lord, the rule regarding peon.
And where is the judgment which says that no such rule has
Page
been?
5 of that compilation only, my lord.
My lord, the Supreme
The
Court
smaller
judgment-
compilation.
No, the judgment of this court, which said no such provision has been brought to the notice of the
Yes,
court.
that has been handed over on the last occasions, my lord. A copy of
It's
the,
not part of the paper book.
my lord, the paperwork has only the division bench এর যে judgment টা যেটা আমাদের ফেভারে হেল্প করেছে।
My lord, that is not the final judgment of the division bench is not there in the, my lord.
It must be there in the earlier paper book.
My lord, the paperwork was filed by our instance. In that paperwork, the honorable division was pleased to allow the appeal. So it was not part of the paperwork. I have handed over on the last
I'm
occasion.
carrying to, my lord.
Give the main file. So that would be part of the order sheet.
Yes, that would be.
Yes.
And, my lord, the paper book which I have filed today contains the Supreme Court order and the rules, my lord, also. My lord, I am separately carrying
What
a
is the
copy.
date of that order?
Yes,
24th
24th of
February
February.
2020.
Yes.